Up in Canada, you do remember that this woman named Zexi Li, a young Chinese student in Canada, sued the trucker convoy along with some restaurants in a class action lawsuit for $290, $300 million. It started off at first for $10 million, I think, and then it ballooned to $300 million. Class action. And as you all know, the steps to getting a class action certified, the first step is to get the class recognized and to get certification to file the class action. They have not yet gotten to that point, despite this file being years in the making. And Zexi Li, people were accusing her because she's Chinese of being funded by the Chinese government, whatever. And I haven't found any meaningful evidence to substantiate that allegation. Others say that she's, funded by the Liberal government. One thing that is clear is that if she's not a willing, deliberate tool, proxy entity of the Liberal government, she's certainly filling that function. And she filed this $10 million class action against the trucker convoys because they interrupted the downtown core. They upset people. If you don't remember this, I'll bring up just a quick article which will summarize where we're at on this. Justice Center for Constitutional Freedoms. This is the news of the day. Actually, we won't even get into that just yet. Let me bring this back out. Suing for all sorts of damages, harassment, noise, trauma, yada, yada, yada. The lawyer in that file who was representing Zexi Li is a guy named Paul Champ. And Nomen S. Omen, dude is not a champ. This is sort of like the ironic name for an individual. I've had my issues with Paul Champ for a very long time. He's a hack of a lawyer, an activist of a lawyer. This lawsuit was always clearly and only intended to be punishment, abuse of the judicial process to go after the truckers, to go after the organizers, to try to bankrupt them. Now, back in the day, he put up a tweet which is no longer there for whatever the reason, and I was mocking this guy for talking about causing distress of the truckers. And I wrote, yeah, cause distress. Yeah, with hugs, smiles, and bouncy cancels, get bent, Paul Champ. Then Paul Champ replies, the Public Order Emergency Commission, the federal court, and at least a dozen criminal trials have all concluded that the convoy obstructing Ottawa streets for 3 straight weeks caused significant disruption and distress to families, seniors, disabled, and workers. Get stuffed. That's gross. And I had to retort to Mr. Champ that perhaps the distress was caused by his client, Zexi Li, that's her on the bottom right there, the plaintiff in this class action suit. Perhaps the distress was caused by her throwing frozen eggs off high-rise buildings onto the trucker protesters who were parked on public streets below. And if you had forgotten about that, Viva forgets nothing. Listen to her testimony during the Rouleau Commission, which was the political tribunal they set up within the year and a half after invoking the Emergencies Act to determine whether or not it was warranted under the circumstances, or at least to analyze the circumstances under which the Emergencies Act was ordered, invoked, and that Commissioner Rouleau concluded that it was, justified. A federal court and Court of Appeals unanimously declared otherwise. We'll get there. This is Zexi Li talking about how she assaulted people during the trucker protest.
Can you describe what you mean by the egg throwing?
Well, there were very large trucks parked everywhere. And in some of these instances, they were parked right next to some high-rise condo buildings. And as a result, some people may have gotten some cartons of eggs and, had their little retaliation in frustration, because really, what else could they do?
What else could they do? The up talk is annoying. The vocal fry is annoying. That's the plaintiff in the class action lawsuit seeking $300 million from the truckers. And Paul Champ, the lawyer in that, let me see where this one's about Paul Champ. When I say that he's a liar, he's a liar. When I call someone a liar, by the time I've called them a liar, it's because I have obtained definitive conclusions based on conduct that they are a liar. Do you remember that incident where this member of provincial parliament, Joel Harden, claimed that he was punched in the face by protesters while he was protecting trans rights and trans kids. And then footage came out of the jackass smashing his bullhorn against his own face. And I said, oh, look, here's the moment you smashed yourself in the face where you had that metal piece right under your eye. This was Kareem Assad who showed the slow down version. Paul Champ came in and said, no. I know that we've got video footage now of this guy, what was his name? Joel Harden. A scandal. The man took to social media to claim that he'd been punched in the face by far-right protesters because he's a lying sack of crap who happens to be a member of provincial parliament for the NDP. I'm fairly certain. Paul Champ, a lawyer, a member of a professional order, comes out and says, video from another angle shows a protester strike the megaphone into his face. Too bad this video by Kareem Assad didn't show the full view. At least he wasn't trampled to death by a horse, I guess. Now, by the way, it was the shifting narrative. He got punched in the face. Oh, no, it was his bullhorn. He hit him. Oh, no, well, someone shoved the bullhorn into his face. Someone says, where's the video, Paul? Link, please. The guy says Harden smacked himself, but the clip actually shows the post of it. And I said, why would you turn yourself into such a liar, Paul? You are a member of a professional order. You referenced a video from another angle. If you didn't have that video, why would you make such a statement? Have you no shame? Because Paul Champ apparently has no shame. We're getting back to the beginning of this, so don't think that I've totally lost train of thought. Because Paul Champ is also a bad lawyer. I can be a bit of a jerk, people. This is Paul Champ right here. I'm circling with my finger. This is Paul Champ during the Rouleau Commission when they were looking into the circumstances, yada, yada, yada. This is him. He's having his moment. I clipped his moment and I said, another masterclass in how not to lawyer, courtesy of Paul Champ. Rule number 1, never ask a question to which you do not know the answer. Rule number 2, when you're in a hole, stop digging. Not the answer he wanted, referencing to Section 2C of the Canadian Security Intelligence Service Act. Listen to this beautiful highlight from the Rouleau Commission, illustrating that this man is a liar, a stupid liar, and a bad lawyer to boot, because he has now gotten caught in a very, very precarious position in the context of that class action lawsuit, which we're going to get back to right after this.
But Mr. Vigneault, let's just be clear that if someone's making a threat against a public official because they're trying to influence that public official, that inherently falls under 2C, does it not? Now, it may be that you don't view the threat as credible, but if it was a credible threat, it would inherently fall under 2C, would it not?
I think that if you, that's why we've took a lot of pain to inside the service and working with partners to better understand how the IMV phenomenon was interacting with the CSIS Act. And Ms. Khan walked us through, earlier, a description of
IMV was ideologically motivated violence, just so people understand the acronym.
Of how we go through the process of understanding this, what will be the sphere of CSIS responsibility, what will be the sphere of the law enforcement responsibility. And that's why I'm saying is that this is not black and white, it's dynamic, and this is why people talk to each other on an ongoing basis.
Sir, please, I'd like to give you normally I'd like to give witnesses full time to answer, but I only have a limited time. I'm just trying to get an answer because I believe I've asked it a few times here. If someone is threatening a public official because they want to influence that public official to take some policy choice, does that not inherently fall under 2C, yes or no?
Each case is looked on a case-by-case basis, and it would not be, a default proposition.
So if someone's threatening to kill a mayor or a premier because they want them to drop a public health measure, that does not necessarily fall under 2C. Is that your testimony, sir?
Yes, it is.
That's the face of a lawyer who didn't understand he was never going to get the answer he wanted. Congratulations for putting on the record the exact answer you didn't want, Paul Champ, because you're a moron, you're a liar, and you're a terrible, corrupt lawyer. And now the news broke today and became public today of the evidence of this. There are rules that apply to class action lawsuits, and there are rules that apply to settling or entering into settlements in class action lawsuits. And the Justice Center for Constitutional Freedom published this today, as did Tamara Leach, who identified, although I already knew it, that the lawyer being referenced in this breaking news was in fact Paul Champ, that allegedly he entered into a settlement agreement with one of the defendants to the proposed class action, then allegedly got the collaboration of that other defendant in the proposed class action without disclosing it either to the court or to the defendants, the other defendants, who were having interactions, communications with that defendant who had now effectively potentially been turned into a mole for the plaintiff. Listen to this. Justice Center for Constitutional Freedom, court to hear motion seeking permanent stay, that is to say, set it on hold forever, of the $290 million Freedom Convoy class action. Justice Center for Constitutional Freedoms announces that a significant procedural development has occurred in the $290 million class action lawsuit targeting peaceful Freedom Convoy protesters and donors. It's procedural that might land this lawyer getting disbarred. And if there's any justice and the allegations are accurate, he will get disbarred. At a case conference held on Thursday, January 29, 2026, Justice Calla McLeod agreed to hear a motion brought by the defense seeking permanent stay of the proceedings because of the plaintiff's failure to disclose a settlement agreement to defendant's legal team. It's crazier than you can possibly imagine because they entered into a settlement with a co-defendant who could basically disclose strategy information by turning an undisclosed, undeclared effective witness collaborator to the plaintiffs. The settlement agreement was signed in April 2024 between the plaintiffs and one of the defendants, Chad Eros. At the time, Mr. Eros did not have a lawyer formally on the court record under the agreement. By the way, getting into transacting with someone who's not represented, I mean, I guess he doesn't have a lawyer, so it's not unethical to be dealing with him directly, but it might show a bit of a tendency to exploit of the ignorance of an unrepresented defendant. Mr. Eros was required to provide, under the agreement, once it was signed, Mr. Eros was required to provide all relevant documents in his possession to plaintiff's lawyers within 60 days. Within plaintiff's lawyers is Mr. Paul Champ within 60 days and take part in private meeting with them to discuss those documents. Mr. Eros also agreed to forward a settlement amount to the plaintiffs within 6 months, all in exchange for his release from the action. However, it is alleged that the settlement funds were never paid. The agreement was not shared with the other defense lawyers until January 28, 2026, nearly 19 months later. For 19 months, they carried on as though there wasn't an agreement between one of the co-defendants with the plaintiffs, where he was going to collaborate with them and basically be a mole to them. Defense lawyers are expected to argue that this delay breaks a basic fairness rule. Settlement agreements like this must be disclosed to all parties right away. Because that did not happen, they will argue that the entire lawsuit should be put on hold. They might argue that Paul Champ should be sanctioned and disbarred for this. Meanwhile, the plaintiffs are expected to argue that because the settlement money never changed hands, there was in fact never any settlement agreement at all, and therefore nothing to disclose. Bullcrap. Defaulting on a settlement agreement is different than there not being a settlement agreement. Him having failed to satisfy a condition of that agreement basically confirms the existence of that agreement, but his failure to abide by it. Much, much different reality. There is no agreement means there's no money to pay. You didn't pay your money means you defaulted on the agreement that we actually had. Leads to different legal consequences. One of which is admitting the existence of the agreement under which he was supposed to pay and provide documents. By the way, it doesn't seem to mention whether or not he provided the documents. Importantly, the court confirmed that this motion will be addressed before any consideration of class certification, which had previously been scheduled as the next major step in the case. A further case conference is scheduled for March 4, 2026. Can you imagine they're nearly 2 years into this and they still haven't gotten class certification? Constitutional lawyer James Manson, who represents Freedom Convoy defendants, including protesters and donors, welcomed the court's decision. Quote, fairness in the justice system depends on full and timely disclosure according to the law, end quote, said Mr. Manson. When litigants fail to meet that basic obligation, courts have both the authority and the responsibility to intervene. A permanent stay and sanctions that is not part of the statement, not part of the quote. A permanent stay is an appropriate remedy where non-disclosure seriously undermines the ability of defendants to properly defend themselves, he added. And I will add, a permanent stay and sanctions. Forget properly defending themselves. How about if there was communication of documents that the plaintiffs never would have gotten but for collaboration and collusion with a defendant that they surreptitiously and secretly coerced into some form of settlement agreement? Class action lawsuit arose from the events in January, February 2022, when thousands of peaceful protesters from across Canada gathered on Parliament Hill to protest federal COVID vaccine mandates. While many Canadians supported the protest, some Ottawa residents objected to its presence, citing alleged nuisances such as honking horns, and idling vehicles. In February 2022, Ottawa residents Zexi Lee and George Delaney, along with Happy Goat Coffee Company and a local restaurant, launched a $290 million class action against Freedom Convoy organizers, participants, and individuals who donated to the protest. Lawyers funded by the Justice Center have consistently challenged the lawsuit as legally defective, arguing that it improperly grouped thousands of individuals together without identifying specific conduct, individualized responsibility, or a causal link between particular defendants and alleged harms. And I'm getting ready to take a big fat victory lap on this too, because I said this case was never going to get certified. This case was absolutely abusive. It was preposterous in the sums claimed. Like, whatever you think of litigation, Canada is not the US. You don't go and sue for $10 billion for disclosure of IRS documents. You don't get $1.6 billion judgments rendered by default against you for alleged intentional infliction of emotional distress. Not that the court system works any better, but at least the abuse is tempered by the quantums the courts tend to issue. It was bogus from the beginning, and now we have egregious confirmation of absolute corruption from that scoundrel Paul Champ, that he was basically extorting, coercing a defendant who did not have formal legal representation into a settlement that they were going to use, and maybe already did in fact use, to procure information they would have otherwise never gotten, or certainly not through those means, and certainly not without the knowledge of the other defendants, so that plaintiffs could abuse and exploit that information in the context of this abusive lawsuit. We'll see where this goes. This should get stayed, thrown out, and Paul Champ should get sanctioned. And that's all I have to say about that.